Well, welcome to the latest episode of Just Settled. Today we have Justin Blitz with us, an incredible personal injury attorney out of New York City. Justin, returning guest, how are you? Thank you for joining us today. We appreciate you being here.
Thanks for having me, Dan. Always a pleasure to be with you guys here.
Awesome. And yeah, you and I were talking a little bit about this case just a moment ago to kind of get a breakdown of some of what went on. So if you can kind of just introduce the audience to this specific case, how you first learned about it, how it came across your desk, and your initial thoughts when you heard the breakdown of what happened.
Sure. We are a small law firm in New York City that is incredibly busy, and we have many of our own cases that we handle from the initial portion all the way to the conclusion. When I started my career, I did trials for many law firms throughout the city, really with great success, I'm proud to say, and took a lot of verdicts. At this point in my career, it's rare where I take another law firm's case for trial. There's one law firm. They probably are the biggest law firm with respect to construction accident cases in the country. And these guys approached me a little while back, and they asked me if I would do a trial for them. And it involved a gentleman who was he was part of a crew that was building a bunch of residential homes in Westchester here in New York.
Okay.
And what happened was, well, when I first got involved, what they told me was he was using a front-end loader, one of these machines that has like a bucket where at the front of it, and you use the bucket to take large loads and move it over. They're used in all sorts of, we've seen them all over construction sites and landscaping and mining projects, agricultural. We would all know one when we've seen one. And in this case, he was using this front end wheel loader, and he got out of the machine and he went to the front of it to look at the foundation of the home that he was building, talking to his supervisor. And after being in front of the machine for about 45 seconds, the machine, which has these big 4 wheels, began to move.
Right.
And the supervisor was able to get out of the way, but our client was not. He did not get out in time, and the front wheel loader crushed him against the foundation of the house that he was building. He ended up suffering horrific injuries, required about 8 or 9 surgeries, was a young man who spent about 3 years in a rehabilitation center and was not going to be able to work again for the rest of his life. And when I got involved, we were about 4 months away from trial, and they hadn't been able to figure out what caused this machine to move.
Yeah.
As I'm sure you're aware, a machine of this size and caliber should not be moving without somebody pressing on a gas pedal.
Yeah, right.
So the case was complicated and it intrigued me. And all they knew was that about 2 years before that, they had hired an engineer who was based in Illinois, And he also couldn't figure out what caused this machine to move. So they had some problems coming into this trial. And when I said I would get involved, I hopped on an airplane and I flew to Illinois. And I spent 6 days in the engineer's home that they hired. And I basically said to this engineer, I am not leaving till we figure out what caused this machine to move.
Right.
And during those 6 days, and mind you, I'm not one, I freely admit I haven't done any construction in my life. I am not, don't have an engineering background. So just the basic terms were foreign to me, and I had to, in many respects, learn a whole new language, as many attorneys who do what I do when we get involved in cases have to learn about the entire industry. And what I discovered was during those 6 days, and we brought in his colleague, another engineer, and the three of us sat around and we figured out that there was a problem with a component of the parking brake system of this machine, something called a solenoid valve. And this solenoid valve was a component that was, in fact, negligently designed and was susceptible to contamination from tiny pieces of dirt that would come into the whole system whenever you would engage the parking brake. And it would cause this valve, which was attached to a spring, and, I'm not going to get into all of the technical terms and the technical components, but frankly, it was designed by about half an inch off of what it should have been. And when it did get contaminated with tiny pieces of dirt particles, it would cause the parking brake to fail. It would cause the electrical power that went through this solenoid valve to be lost. Okay. So that took many hours of us trial and error and really brainstorming, and me probing these brilliant engineers on what went wrong here. Now we had to, then once we figured out what in fact was the problem, and often is the case, once you figure out the problem, then you know where to look. And what I mean by that is, okay, did this company that made this wheel loader, which by the way was the largest, still is the largest company for construction equipment in the world, did they know that this particular valve or this particular model of this front loader, did they know that it was prone to cause these issues?
Right.
And sure enough, we went back. We now knew what to ask for. And during the course of the litigation, they had given us something like 60 to 70,000 pieces of documents.
Right.
And we did not know that there, in fact, as part of their 60 to 70,000 documents that they had already previously given us, was the evidence that we needed. It was already given to us. We just didn't know what to look for. And what we discovered prior to the trial, and when I mean prior to the trial, I'm talking about the weeks and days leading up to the trial, was that in fact the company, the largest construction company in the world, had known that this particular valve was designed improperly. They had received numerous complaints from customers throughout the country, and they very much were kicking the problem down the curb to hope that it would not cause such catastrophic injury as it did in our case, because it would have been, frankly, so incredibly expensive for the company to recall this valve, and they had sold thousands upon thousands
Right.
of these front loaders all throughout, not just the country, but throughout the world. And we're talking about many hundreds of millions of dollars where they would have had to recall these machines and reinstall a parking brake system that would have been fail-safe and that would have had the proper valve. So as is often in products liability, that's what types of cases this was. Corporations tend to do a cost-benefit analysis, and at the end of the day, they are beholden to their share price and to their shareholders. And frankly, I think that they made that cost-benefit analysis with the determination that this just would have been such an expensive endeavor that they would have rather have taken the risk for somebody to be able to prove in a court of law that this tiny little component, which was one of maybe about 5,000 components of this particular machine, was off and wrong and defective. So
speaking of that part, were there like the concerns and uncertainties about this case and how the outcome, was going to play out? Were there concerns around just the size of this company, or what kind of were your biggest, not worries, but just where did you kind of see potential challenges coming up in this?
So it was a very complicated engineering theory that we had, and that's in itself a complication, because how to break this down to a jury of lay people to explain to them. But also when you sue any Fortune 500 company, we can expect to go up against the best of the best and many brilliant minds that we are going to be outspent, and we are going to be outgunned, and we are going to be outmanned. And when I showed up that first day for jury selection on this trial, well, I knew what I was facing, because when I looked across the room, it was me. And on the other side were 24 attorneys that they had flown in from all across the country, and that were prepared to defend their corporation and prepared to defend their actions. And in fact, I later learned that these 24 attorneys, this is what they did. They went all across the country from courtroom to courtroom defending this company. So they were certainly more well-versed than I was. And I guess we did learn leading up to the trial what we would be facing, because in the week before that jury selection, we received 25 motions in limine. A motion in limine is a motion which is a application to the court to seek to either preclude or allow certain evidence at the time of trial. And they were clearly trying to preclude as much evidence that was favorable to me from this jury. And we had to spend hours upon hours opposing all 25 of these motions, putting in papers, arguing against them. It took us 2 days before jury selection just to argue each of the preliminary applications, the motions, and then another day for the judge to rule on all 25. And then we began our jury selection.
Sorry, go ahead.
Yes, please go ahead.
No, just at that beginning stage, kind of when you were coming into the jury selection and the trial, what were you thinking in terms of value of this case? Or I guess what was the client's hope or expectation in terms of restitution going in from the beginning?
It's a very interesting question, and there was no question in anybody's minds that his injuries were of the catastrophic nature,
right,
where real significant money would have been the only fair compensation for all the harm caused. However, we also know, as when we take into determination the value of a case, it's not just the significance of the injury, it's the first part. Can we prove that the other side was negligent? Can we prove that the other side's negligence caused these injuries? And if there's a question on that first portion in terms of establishing negligent bad acts that caused the injury, then you certainly need to take off. If a case is worth $1, with that first portion is called liability. If the case is worth $1 with perfect liability, if you don't have perfect liability, maybe you think about taking 60 cents or 70 cents on the dollar. The lawyers involved and the client involved were everybody understood that we had a very tough road ahead of us on the first portion of this case, establishing every lawyer and the client knew from the get-go that we had a tough road ahead of us, establishing that this product, this wheel loader, was designed defectively, manufactured defectively, and that the company knew about it. And that was going to be a battle. So we begin our trial. We finally have a jury picked. And mind you, the amount of money that was offered throughout the years leading up to the trial, and for the first week of the trial, then for the second week of the trial, the amount of money was $0. They were confident. I flew in our engineers from Illinois. I had camped out at a hotel a block from the courthouse, and I was living, breathing, eating 24 hours a day this case. And we were putting on witness after witness, and we put the plaintiff on, and we put the experts on, and they had experts. And it was a tough battle, there's no question. And then we subpoenaed the chief engineer of this multinational, huge construction company. He was responsible he had about 500 engineers under him. He was the honcho. He was the jefe. And they flew him in on their private plane, and they brought him to the courthouse, and it was almost like he was Michael Jordan when he came through. They brought him in with security surrounding him, and all of a sudden there were the 24 lawyers that were across the table, and now there were 10 more lawyers behind me. And I mean, you literally would have thought that it was Michael Jordan coming to a courthouse. And I knew that his testimony was going to make or break this case. And I was very prepared for him. And I had spent many, many, many hours getting ready for this cross-examination. And the cross-examination that I conducted of this chief engineer lasted 2.5 days. And on the third day, after 2 full days, I had a breakthrough. And I was really able to, what frankly was, I was able to show that he knew, the corporation knew, that this solenoid valve was defective. He knew that when they sold the machine to suppliers and stores across the country, who then sold the machine to construction companies and lay people to use the machine, they never told the suppliers. They never told the retail stores. And they buried deep, 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 deep into their closet all of the tests that they had done internally that showed that this was a defective product. They had buried the customer complaints that would have given them ample notice that something was wrong with this machine. And there's not oftentimes at a trial, it's unlike what we see on TV and the movies where you get a aha moment.
Sure.
But I was able to get that aha moment. And that came from one of the documents that they had already given us 3 years before that was buried in the 70,000 pages of records. And it was number 47,825. I remember that well. And it was one piece of paper. And it had come from a very high up meeting amongst all the executives of this corporation, where they had freely admitted that they knew that this solenoid problem valve could cause the parking brake to fail, which could cause this mammoth machine to move without anybody in it causing injury. It was a proud moment. It really was.
Right.
And just to finish up the conclusion, we broke for the day, and I went back to the hotel, and I had another couple more hours to finish the cross-examination, which would have been the 4th day. And when I got to the courthouse, I could tell that things were different.
Yeah.
There were some people in suits that I had never seen before. And the judge brought me back to his chambers. And 2 hours later, I'm proud to say that we walked out with a settlement that equaled over $10 million.
Yeah, it's incredible. So obviously in this case, there were some of the typical opposition and obstacles, like the defendant lowballing and trying to kind of shirk responsibility and those types of things. The unique challenge seems like it was the fact that it was an enormous company with a huge amount of power behind it. And, you were going up against kind of a David and Goliath type situation there. You said the whole case was 3 years, right? From beginning to finish in terms of when you first heard of it till the outcome of it?
Well, the the litigation leading up to the trial had lasted 3 years. I got involved and had first heard about it 4 months prior to the trial.
Okay, so 4 months prior to the trial, and then how long was the trial itself from?
So when we were able to resolve the case successfully during the course of the trial, we were in the third week of testimony.
Okay, so that's pretty quick, actually, right?
We were nearing the end of the third week, and we had a judge that was a hardworking judge, and we were putting on for 3 weeks straight, witness after witness after witness, and it was we probably had another 3 weeks to go.
Right.
If I had to range, so we were right about the halfway point of the trial.
And so was that a settlement or was that a judgment?
So
Technically,
it was a settlement. Many cases get settled during the course of a trial. I like to say when the jury is coming down the elevator, begin the trial, that's when we typically see a real offer. But, it's like when your back is against the wall.
Yeah.
That's when the real money comes.
Yeah, and you got them to throw in the towel, really, which was kind of obviously super impressive. And it sounds like that aha moment where you kind of cornered, that big honcho guy, and kind of got him to admit that, he knew about it. When they were negotiating back and forth, you said when they came in, they were offering zero. How did that 10 million number come about? Obviously, you kind of explained how you advocated for your client's interests and how you really kind of solved this mystery in front of everybody and got them to admit fault. But what kind of determined that settlement number? Because it's an impressive number. And then I guess after that, you mentioned the client was in rehab. How did it change his life in terms of getting that money?
So when we value a case such as that, we have economists that we hire. We have life care planners that we hire. And what the life care planner does is they will provide estimates of costs of future treatment. We also have vocational rehabilitation specialists, and a vocational rehabilitation specialist will make a determination based on the person, their education, their background, and their history, and their injury as to what the prospects of future employment are. And we take all of that into consideration. We also then have to gauge, there's no slam dunks in this world. What if we had one of the jurors who didn't believe us? And what if that person's opinions held the day and he convinced everybody else, and we can walk away with zero? So these are there's so much that goes into what is an appropriate number to settle a case. Frankly, it's also the plaintiff. How much does he want to weigh? This is his life, and this is you don't get to go back to the courthouse in 2 years and say, I actually needed more. I actually need more surgeries. This is the one and only shot. And what we do as attorneys is we are constantly weighing the cost-benefit analysis. We are constantly weighing the risk versus the reward. And then we can offer our advice and our opinions. But at the end of the day, it's the plaintiff who decides whether they are going to accept the money that is offered or not. And, once they realized that my hard work had paid off and they were in a bind, uh, then we had leverage on our negotiations. And they did not start at that number that we resolved it at. They started a lot less. And as all negotiations go, we start very high, they start very low, and we hope that we can meet somewhere in the middle. And I like to say to clients that a good settlement is when both sides walk away just a little pissed off. If one side walks away and says, wow, that was incredible, it was more than I expected, that's not typical for your average settlement. The settlement always will involve some sort of compromise from both sides. And so weighing in the experts, weighing in the economic realities, weighing in the jury makeup, weighing in how the testimony went in, that's how we got to the number that we ended up taking to resolve the case.
Yeah, and I mean, it's an incredible number. That client was obviously very lucky to have come across you. You always do amazing work. And thank you for sharing this case with us today and kind of going through it in detail. It really, really is very interesting. Justin, we'll hope to have you on again. And just thanks for being here.
I thank you so much, Dan. It's always a pleasure being with you. You guys do great work. And I always look forward to sharing my stories to hopefully inspire young attorneys and anyone else listening. And I guess the moral is here, don't ever give up and keep working hard, and hard work will pay off. That is a promise.
Awesome. Love that. All right. Well, thank you for joining Just Settled. We'll see you next time, Justin.
Thank you so much, Dan.